Welcome back to Presume Legal. I'm Misha Janice, and this is the recap of trial day 18 in the Commonwealth versus Karen Reed case. Grab your red solo cup, pour yourself a drink, and let's recap. Brian Higgins retook the stand to continue his cross examination this morning. He was asked whether, when he disposed of his phone after receiving the preservation notice, if he factory reset it. He said he didn't, but they called him on it because he had made a prior statement last May during which he said that he had factory reset the phone. In today's testimony, Higgins denied the accuracy of that prior statement. He said if he did that, this is what he would have done. What? Sounds like OJ's If I Did It. Like, what? So, if he did it, he either broke or cut up his SIM card in order to destroy it and put it into a trash bag along with the phone. This is what this man did. He destroyed the SIM card. He drove to a military base where he threw the SIM card and the phone that were both in trash bags in a military dumpster. Before he drove away, he did not transfer any data to the brand new spanking phone that he got. He didn't transfer any of the text messages that he had with Brian Albert, Kevin Albert, or Nicole Albert, nor did he transfer any other data such as, sweet messages or voicemails or pictures or videos from his dearly departed sister who died tragically or his father, both of whom he testified he had recently lost. He said he had a better connection to his work phone because he was a divorced man with no kids, so he didn't have tons of memories that he wanted to keep on his personal phone. So he said he threw the stuff away, even though he had not received any notice that the preservation order had been lifted. And on that note, the defense completed its cross examination. On redirect, the Commonwealth attempted to rehabilitate its witness. He clarified that in the police department Sally Port, it requires a key swipe for both entry and exit from the doors. I have a feeling that may come back into relevance at some point. He was also asked about the preservation order. He said he received it on September 30th of 2022. And on October 21st, so almost a month later, he said he learned that the motion had been denied earlier that month on October 5th. He said he threw the phone away 2 months later because his old phone was beaten and broken and he had already had the new phone. But why did he change his phone number? He said that in July of 2022, a target in one of his investigations called him on his personal phone. And ever since then, he wanted to get a new phone number. About his visit to the military base, he said that when he would go to the military base for gas or to visit the commissary, he would occasionally bring his trash from home and toss it into the military dumpster. He said he didn't have trash service at his house, so he would drive his trash elsewhere to dispose of it. How convenient. On recross, Higgins testified that despite his concern over his personal phone number being publicly available, he didn't change his number until September 29th, 2022. The next day is the day that he received the preservation order. Now, friends, I do not think this is a coincidence. Both he and his good friend, Brian Albert, both so happened to tamper, destroy, get new phones the day before the preservation notice was served on them. Really? Naturally, I'm wondering, how did they both know? Were they tipped off? Were they just following the case, following the filing, saw that the motion had been filed? In my opinion, this reeks of knowledge and an orchestrated attempt to skirt the system. So I don't know if we're going to get down to the bottom of this. The next thing that happened in court was the judge announced that there would be no media in the courtroom for the next couple of witnesses. They were the minors. There was a media ban in place, so we didn't get any information about the testimony. Maybe later, I haven't checked yet any reports of what the testimony entailed, but this was John O'Keefe's niece and nephew, who are both underage, and they were minors. And just according to the strict media ban for their protection, no media was allowed in the courtroom. I can only speculate as to what their testimony entailed. I can imagine it would cover uh, January 28th and 29th from the niece's perspective, what she heard and saw, and probably testimony from both of them about the Aruba trip and the interactions between John and Karen that they witnessed, uh, while living in the house with them. The next witness was Gary Fowler, a pathologist at Good Samaritan Medical Center. He is the chief pathologist and the laboratory medical director, and his job is to ensure that lab reports are accurate. He explained the policies in place at the hospital for employee trainings and competencies in performing tasks like blood draws. Now, the witness was given records that he identified as the defendant's blood alcohol test results, which came back as 93 milligrams per deciliter. And he went on to describe each step of the process of a blood draw, how it's done in their facility, how the phlebotomist uh, validates and confirms the identity of the subject, how they take and label the blood, how they send it to the lab within the hospital, how the lab puts the samples through a centrifuge to separate the components of the blood. And for alcohol blood testing, they test the plasma, which is also called serum, and plasma shows a slightly higher blood alcohol content level compared to whole blood that's not separated. He explained hospitals aren't in the business of converting the plasma levels to a actual blood alcohol content number for legal purposes. And he explained that there's different formulas that could be used to make the conversion, but that's not his realm of expertise. What he did say was that Karen Reed's levels were taken at approximately 9:08 a.m. On cross-examination, defense confirmed that hospitals are not in the business of calculating blood alcohol content levels, and that there are differences between screening tests in hospitals and forensic tests done in labs. He said that the plasma tests done in hospitals don't measure alcohol directly, but rather the byproduct, the NADH enzyme, of what's created when the body breaks down alcohol. He admitted that hospitals test the way they do for efficiency to assist with medical treatments, not for legal purposes. And he explained that there are some factors that may lead to heightened levels of NADH that are unrelated to alcohol consumption, but said that the machines used in his hospital are very sophisticated and usually flag for those possible extrinsic factors. But he admitted that the tests do not establish the timing of when alcohol was consumed. On redirect, the witness testified that on the defendant's test, Karen Reed, there were no flags for interference factors that might cause the test result to be inaccurate. He said that if any of the three major interferences, high lipids, hemolysis, or high bilirubin, were present, it would have been flagged in her report, and there is no such flag there. The next witness was Nicholas Roberts. He worked in the toxicology unit at the Massachusetts State Police Crime Lab in 2022. He testified that the state lab was internationally accredited, and he and another lab tech worked together on serum or plasma conversions. He said that the lab would receive the plasma serum results from a hospital. And because the blood content levels are higher in serum compared to whole blood, he would perform the conversion of the serum quantity to the whole blood quantity. He performed that process on Karen Reed's blood sample records on May 3rd, 2022. And he used that starting number of 93 milligrams per deciliter to provide a low, medium, and high range for what the whole blood alcohol content was for her. He said that the range accounts for different factors in an individual, like their age, their sex, the water content in their blood, the food or other stuff that they may have ingested. The calculations he made for Karen Reed's blood alcohol content, converted into percentages for her, were a low range of 0.078 to the upper range of 0.083. Next, he explained what retrograde extrapolation is. He said it's a calculation that allows one to calculate what a blood alcohol content level was at an earlier time than when the blood was drawn. Remember, I said that her blood was drawn at 9:08 a.m. In order to do a retrograde extrapolation, he needs to know what the alcohol content was, the time the blood was drawn, and the time of the last alcohol consumption. He said they calculate a minimum and a maximum calculation to get another range. They did this process. He did this calculation for Karen Reed, and he said he usually gets a police report that includes the time of a person's last drink. In Karen Reed's case, the police report stated that her last drink was at 12:45 a.m. Based on that, the minimum calculations that he calculated was 0.135 and the maximum was 0.292. On cross examination, they established that because the hospital provided the state lab with the serum, the lab's results cannot fall under the forensic accredited standards because the forensic accredited standards only apply to the state lab. But because the lab was getting samples from a different facility that has not undergone the same accreditation standards, they're unable to apply the forensic accreditation standards to the particular results that he was sharing with us today. He said that his protocol is to conduct confirmatory tests to ensure no errors in the test results. He admitted, though, that the conversions he used are based on scientific studies and that individuals can be wildly different, which could result in much higher or lower blood alcohol content levels. He said that the more unknowns or inaccurate elements in the calculation itself would result in inaccurate results. And he admitted that the range in the results is quite a large range from 0.135 to 0.292. For purposes of the calculation, he said that if the defendant drank alcohol after 12:45 a.m. and before 9 o'clock, which is when her blood was drawn, the entire calculation would be invalid. On redirect, the Commonwealth attempted to rehabilitate the witness by confirming the very important times that he used for his calculations, but on recross, he testified that the 12:45 ending alcohol consumption time that he used, upon which he based his calculations, that was provided by law enforcement and it was not provided by the defendant herself. So that calls into question, did Karen Reed stop drinking that night at 12:45? Was it some point earlier? Was it some point much later? I don't know if we'll ever know. But the fact is that 12:45 seems to be a somewhat arbitrary time. So that calls into question the results from the state lab. The next witness was Michael Trotta. He's the superintendent for Canton's Public Works. In this position, he's in charge of the logistics of the sand trucks and the snow plows during snowstorms. He was asked about the night of the snowstorm and who was assigned to the route covering Fairview Road. He said Brian Loughren was. He was assigned to that route. He said the drivers are instructed to plow through the middle of the roads to keep roads open as much as possible. On cross, he was asked about speaking with Trooper Michael Proctor on February 3rd. The witness said he only spoke with Proctor once over the phone, never in person, and that he, quote, may have, close quote, told Proctor who the plow driver was on Fairview Road on January 29th. Whether he did or didn't, he said Proctor never asked him to speak with Brian Loughran. The next witness was Louis Judress, the IT manager of the Kenton Finance Department. He works alongside two other employees and received a notification from Lieutenant Gallagher that the state police would be reaching out to him to obtain some surveillance footage from around town. He said that the request was for two different places. The first around a particular building in town, and the second was around Town Hall, the library, or anything facing towards Washington Street. He said that all the cameras are audio only, they're motion sensitive, and the footage is date and time stamped from a nationally recognized time server. He testified that nobody has access to remove footage from the cameras. The next thing we were shown was a still shot from video surveillance from the public library along Washington Street from midnight and a second screenshot from 5 a.m. And that's all we saw. We did not see video footage. We just saw the still images, one from midnight and one from 5 a.m. And the differences in between those were at midnight, there was very little snow on the ground. And at 5 a.m., there was a good coating of everything on the ground by then. Now, curiously, the prosecution asked the witness to confirm the identification of the compact disc that he was handed that contained the still images and the video footage that was presented. He was asked whether the disc that was already shared with the defense counsel and was in evidence was the same disc that he previously provided to the troopers, the state troopers. The witness looked at the disc and said, "This isn't what I gave to the troopers." Oops. Lawley immediately asked for a sidebar, and when it was finished, ended the direct examination. On cross-examination, the witness confirmed that Trooper Dunn from the state police asked for 2 hours of footage from 12 to 1 and from 5 to 6 a.m. on January 29th. The witness said he pulled the requested raw video, but he did not view the full resulting footage. And because of that, he said he didn't know if there was any missing footage. He said he knew he was pulling footage for a motor vehicle accident, but not the specifics of the accident. He didn't download any footage to preserve it beyond the 30 to 60 day lifespan of the surveillance footage because he was never asked to. So, this is where the day ended, trial day 18, which happens to be the only trial day for this week. We heard multiple witnesses on this day. We started the day with Brian Higgins finishing his cross examination. We heard about how he destroyed the SIM card from his old phone and threw both items away on a military base despite having received a preservation notice and not having received a cancellation of that same notice. The jury, but not us, heard from John O'Keefe's minor niece and nephew. And once media coverage was allowed again, we heard from the chief pathologist at the hospital where Karen Reed's blood sample was taken for blood alcohol purposes during her Section 12 hold. We learned that her sample was taken at 9:08 a.m. And after the sample was taken, the records were provided to the Massachusetts State Police Crime Lab, where the lab technicians converted the blood alcohol findings from the hospital results into a forensic blood alcohol content range based on formulas used in the field to make that conversion. The blood alcohol content range was a large range, and we know that that may not be super accurate since it's based on information provided by law enforcement, and it could also be wildly impacted by the individual's unique body composition. The retrograde extrapolation that was used to calculate the defendant's blood alcohol content at an earlier point in time is further problematic in my opinion, because it was based on information without factual basis, such as the time of her last drink of alcohol. We heard from a manager at Canton Public Works who deals with logistics of deploying snowplows in Canton. He said that Brian Lofgren was scheduled to plow on Fairview the night of January 28th and that he may have told Proctor Brian's name. And finally, the last witness we heard from was an IT manager for the town of Canton who provided the state police with 2 hours of video surveillance from around Canton. The Commonwealth didn't show us the entire footage, so I'm not sure why they introduced it, but the defense asked some questions that were sustained about whether the witness knew about missing footage. So the jury and us heard a sneak peek of that, but we'll have to wait for another day to see if we get any additional information on that subject. This is only the this is the only trial day for this week, so I will see you guys next week with more Karen Reed trial recaps. I hope to see you then. Thanks for watching. Until the next drop. Peace.